Good evening, everyone. Welcome to the EthiQal Navigating the New HPCSA Booklet number 19, the Ethics of Billing webinar. My name is Amy Wolf. I'm a CPD consultant, and I'll be your host tonight. We have a full program planned, so let's jump in. First of all, I would just like to orientate you to our disclaimer. Our ethics webinar tonight is a conversation between stakeholders. It's not legal advice. We're sharing some perspectives, and the case studies that you will see are purely fictional, and any resemblance to actual cases is purely coincidental. So for those of you who may have missed some of the introduction, just some general housekeeping rules. Questions can be raised using the Q&A function, and we will get to as many of those as we possibly can tonight. There will be a series of multiple choice questions run throughout the webinar, and we encourage you to participate. All answers are anonymous. If you attend the full webinar tonight, you will be entitled to claim 2 ethics points. We have developed an ethical billing resource for you that will be available from the 2nd of April. CPD certificates will be sent within 4 weeks of the webinar, and there will be a webinar recording for those of you who miss it or have a colleague who want to catch up and didn't manage to get a space, and that will be available from Friday, the 2nd of May. I'd like to welcome our wonderful group of subject matter experts tonight who will form part of our faculty and panel. So Dr. Simon Strawn is a practicing pediatrician at Life Bedford Gardens Hospital here in Johannesburg. He also serves as the CEO of the South African Private Practitioners Forum, which represents more than 4,500 specialist private practitioners nationwide. Under his leadership, the organization actively engages in healthcare policy discussions, striving to improve the quality and accessibility of healthcare services in South Africa. Dr. Strawn is also a steering committee member of the Universal Healthcare Access Coalition that advocates for practical solutions to achieve universal healthcare coverage for all South Africans. Welcome, Dr. Strawn. Then we have Dr. Makaluma. He is a qualified general medical practitioner with a master's in medical law and ethics from the University of Pretoria. He has more than 20 years of experience in the health industry, from operating his own private practice to consulting in corporates and healthcare consulting. At EthiQal, he provides medical legal advice on various issues affecting the doctor, and he is also the interface between doctors and the legal and risk management processes. Mpho Mbodi is a medical technologist by trade, but also has further qualifications, including a bachelor in health services management, an MBA, and he's currently studying towards his LLB. Mpho has work experience in both the private and public healthcare sectors, and he is now the head of professional services at the HPCSA, with a special interest in how strategic processes, policy, and people interface. Welcome, Mpho. And then we have Dinero Pillay. Dinero is a dispute resolution and litigation lawyer and an admitted attorney of the High Court of South Africa. He is a director at Norton Rose Fulbright and heads the South African medical law team. This specialist team primarily focuses on the defense of medical malpractice claims against private hospital groups, 2 provincial healthcare departments, and medical practitioners. The team also provides regulatory and insurance advice in the healthcare service. Dinero is also a member of the Norton Rose Fulbright South Africa Supervisory Board of Directors. Thank you all very much for your time and commitment to sharing your knowledge with our audience tonight. So in order to get a better feel for you as an audience tonight, we're going to invite you to complete a series of multiple choice questions. These are all anonymous, just so that we can get a feel for who we are working with tonight. So our first question is, I am, and you will choose one option from the following: a medical student, a GP, an allied health professional, a specialist, and a practice support staff member or other. Marcel or Dane, can you please bring up the poll for us? And if I can invite you all to join, apologies, all to vote for the answer that best describes you and your role. Wonderful. So it looks like we have 63% of the group is specialists, with allied health professionals as the next biggest group. Wonderful to have you all here. Thank you all for joining. Right, next question. I have been in practice for. Choose one option. Less than a year, 1 to 5 years, 5 to 10 years, 10 to 15 years, more than 15 years, or other. Dane, Marcel, please could you bring up the poll for us? Okay, if I can invite you all to vote at this point. If you've just joined, welcome to the session. We're doing a few introductory questions to get a feel for the audience. So I invite you to please vote for which group, well, how long you've been in practice for. All the feedback is anonymous. It just gives us a feel for who our audience is tonight. Dane, Marcel, if I can ask you to please close the poll, bring up the answers for us. Okay, very interesting to see that the majority of the group have been practicing for more than 15 years. We're looking forward to learning from you tonight. All right, next question to answer. Please choose one of the following. I work in the private sector, the public sector, both the private and public sector, or other. Dane and Marcel, please, if you could bring up the poll for us. Thank you very much. If you'll choose the answer that best applies to you. Okay, majority are in private sector. Really helpful for us to orientate. Thank you very much. And then the last question. I am attending tonight, and the good thing is you get to choose more than one option. So I didn't know that the HPCSA Booklet 19 exists. I'm struggling with patient billing. I have a current patient billing complaint. My patients complain when there's a co-payment. I want to check my current billing practice or other. Dane, Marcel, if you can bring up question number 4 for us, please. Remember, you can choose as many options as apply to you. All right. Many of you don't know that Booklet 19 exists. That's really helpful for us. You want to check on your current billing practice. Wonderful. Okay, we've got some great information to share with you, and you've got all the best experts. Okay, thank you, Dane and Marcel. And now I'm going to hand over to Dr. Strawn. Dr. Strawn, would you like to share your presentation and open the session tonight with an overview of Booklet 19 and the key areas where healthcare professionals get themselves into trouble? Okay, we can see your presentation. Beautiful. I'll hand over to you. You may want to switch on your camera.
So fascinating to see that the majority of people attending are more than 15 years in practice. It's interesting that whenever we have run in the pediatric group of, I'm a pediatrician, been in practice 31 years, whenever we run any kind of practice seminar, even if we try and restrict it to those in the first few years of practice, thinking that they're the ones who probably need it the most, half the audiences usually are more than 15 years in practice, which just goes to show how complex all of these things can be. And even though you get good guidelines that have been provided in Booklet 19, you still come across eventualities where you're not entirely sure. Now, Booklet 19 is a booklet that encompasses rules that have been around for many of them for ages and ages, but they've been contained in different places, and this book just brings them all together. And remember, the booklet, the primary aim is to provide guidelines for fair and transparent billing, and it's there to guide the profession and protect the patient. The laws and ethical rules contained within this and referred to within this booklet ensure that billing is fair, legal, and transparent, and practitioners must follow these regulations to protect patients and maintain professional integrity. Remember, of course, that what you're wanting when you're seeing a patient is to go on the journey with that patient. And for that patient to join you on that journey, you need to have the patient trusting in you, and you need to be able to give the patient the information that they require in a way that they understand, so that they retain that trust in you right through their treatment journey. And remembering also that the ethical rules and guidelines of the HPCSA are used in adjudication of complaints. It's not just the legality contained within the Act. In some instances, they don't even ask about the Act. They ask, were you compliant with the HPCSA ethical rules and guidelines? So this is important because accurate billing, and this booklet goes a little further than just billing. It actually gives you a very clear blueprint of how really to maintain the patient's trust and to maintain your reputation as a practitioner. It helps to ensure that you are compliant with legal and the professional guidelines, and it prevents any kind of nefarious billing, over, under, improper billing. And by doing this, it will avoid or mitigate legal consequences in cases of professional misconduct. So it's really important for everybody to be very aware of this. Now, if you've read through this or you're aware of billing practices, you know that there are various acts to which these relate. Now, what's important here is to look at what we are required to tell patients and what the various acts tell us. So the National Health Act says patients have the right to be informed about their health status, the range of diagnostic procedures and treatment options, the range, not just the one that you are planning to do, but what their options are, with the benefits, the risks, the costs and consequences generally associated with each option for treatment. So each option. So it's incumbent upon us to make sure that our patients are properly informed of all of their options. And patients have the right to refuse healthcare services and must be informed of the financial implications of refusal. So if you've done all the hard work and you've explained it to them, the patient has every right to say, no, thank you, I don't want this from you. But you then need to go a step forward and explain to them what it might mean for them in terms of they can't now come and claim for services that you've already rendered, for example. The Health Professions Act, this is important now. The practitioners must inform patients of service fees before treatment when so requested, or when the fee exceeds the usual fee charged, and disclose the standard fee and justify the difference. Now, this you might go and say, oh, gee, I never realized that I didn't actually have to tell the patient what the service fees were. This is what the Professional Health Act says. What you've read in the National Health Act above is a little different from that. We're saying you need to discuss it with patients, and practitioners must provide a detailed statement of account when you've actually billed a patient. That's what's in the Health Professions Act. Further, then, the Medical Schemes Act, schemes have the right to access treatment records for financial audits. Treatment records. Medical schemes have agreements with their patients, with their clients who are our patients. And these patients, when they sign the agreement with the medical scheme, actually sign consent for the scheme to access their records from you for the purposes of financial audits. Information obtained in financial audits cannot be shared without patient consent, so that's by the scheme, and patients must receive statements of accounts reflecting all payments made and outstanding balances. Now, this is where the thing about split billing comes in. You can't submit a half of the account to the medical aid and claim the medical aid portion and give the patient an account with the other half on and claim from them. That is called split billing, and that is not allowed. You can, however, have two amounts, 50% for whatever percentage, some for the medical aid, some for the patient, but they must be reflected on the same account, and that's called balance billing. In the National Credit Act, it says that medical billing is not classified as consumer credit, meaning that you cannot charge interest on outstanding amounts. Practitioners cannot charge interest on unpaid medical bills beyond the regulated limit, and practitioners may not impose exploitative financial penalties on patients. If a patient has not paid an account and you now want to go through a legally accredited debt collector, you are within your rights to do that, but you can then only charge 2% interest according to the HPCSA guidelines. So the ethical and professional rules of the HPCSA, practitioners cannot accept or pay commissions for referring patients. Overcharging, underservicing, or financial exploitation of patients is unethical, and practitioners may not share fees with individuals who did not contribute to the service rendered. So if you're in a group practice or you have a locum, that's fine, because they are participating in the care of the patient, but you can't share fees with a pharmacist or somebody else, and you cannot take you cannot be incentivized. I once had a grandfather who offered me a monthly retainer to look after all his grandchildren. He was quite happy to pay me all my consultation fees at the time of service, but wanted me there, and obviously I was not able to do that. Patients must receive full and accurate information about their treatment, including costs. This is in the National Patients' Rights Charter. Patients cannot be misled about financial obligations, and you may not withhold anything from patients, even if they don't pay you. They still have a right to the blood results and even to their file if you've seen them. Healthcare providers must ensure financial transparency in all billing practices. I mean, this seems, I'm sure, to 95, 99% of all healthcare practitioners, this is kind of how you practice. You take the patient along this journey, but these excerpts are being very explicit in saying you need to discuss everything with patients. You need to discuss with them, you need to get consent from them. Not just consent for your proposed treatment, but financial consent for the financial burden that they or their medical aid, and this applies to even to medical aid patients, even if you're a DSP, even if you're signed up to a payment plan with medical aids, the patient is the person with whom you are dealing, and they need to know. These booklets are referred to in the document, and I cannot stress strongly enough, you have to read these booklets, and you really should be reading the sections of the acts to which they refer. This is your business. This is our responsibility. This is the duty to our patients to be completely informed of what the processes are that we're supposed to follow. So transparency and disclosure, we've referred to that, inform patients of fees before treatment. Before treatment. Obviously, if it is a comatose patient, a patient who is not able to give, to take that informed consent, to be informed, it's like in pediatrics, I speak to the parents. Sometimes the parent bringing the child, in fact, is not the parent who's responsible for the account. If it's a divorced situation, we need to be aware of that. If there is a family member at a resuscitation or at an emergency, if at all possible, inform them about what's going to happen and what the fees are. Fair and consistent billing. Fees must be rational and consistently applied. It is not okay to have variable fees for PMBs. It is not okay to have one rate for PMBs because you know that medical aids have to pay it without copay. It's not okay. Your fees need to be consistently applied. Emergency care must be provided regardless of ability to pay. Advance payments are not allowed. They're only allowed if the patient is liable for a copay on their medical aid and there is a planned procedure. Then you can ask the patient to pay the non-medical aid portion beforehand. You may ask for upfront payment from a foreign patient, and you may ask for upfront payment for prostheses that are going to be used. You can use a legal debt collection, but you may not withhold care from a patient. And as I've mentioned, the interest on debt collection. Invoices must be detailed, itemized, and provided separately from credit bills. And you know that these invoices and statements must be provided in a reasonable time frame and must contain as much information as possible, and they have to contain ICD-10 codes. And you really should be coding your ICD-10 code down to the finest granularity that is possible. Most most practice management systems, few of them will allow you to add more than 4 or 5 ICD-10 codes, but that's not impossible. If I've got a tiny baby in ICU, it's very easy for me to end up with 4 or 5 ICD-10 codes in a patient. But you need to give as wide and as granular ICD-10 codes. Why? Because that's a true description of what you've done. And if there's going to be any question around the services that you've offered, and you've put a non-specific code, where in fact there were 3 or 4 different diagnoses in quite a complex patient with comorbidities, that's not going to be reflected on the statement that you provided. So that's very important. You need written financial consent. Written financial consent is required before billing. Now, this is important because when patients come into your practice, you may have a consent form that they sign, or there may be something on the front of your file, or if you're electronic, they may do it on an iPad or something. But this means that every procedure that you do, that what they sign in your rooms is not all, doesn't cover everything. You need to be able to do it for every procedure that you perform on that patient. And medical schemes, as I've mentioned, can review patient records for audits. Failing to disclose costs upfront leads to patient disputes. Charging for services not provided is an ethical and legal violation. Improper use of billing codes can result in medical aid rejections and fraud, waste, and abuse and error audits. Not keeping detailed financial records puts you at great risk. You've got to make sure your records are well kept, that they are safe according to the POPI Act, that they are easily accessible, that they are clear, that they are dated, that they are signed. Refusing treatment due to non-payment, except in non-emergency cases, violates the patient's rights, and healthcare providers can decline treatment if the fees are not accepted. If you've had this discussion and you've told the patient about the fees and they say, we can't afford that, or we don't want to pay that, or you have a right to, before you embark on whatever planned procedure or consultation it might be, you have a right to decline that treatment, but you then have to refer the patient on to somebody for the same level. I've just now quickly distilled this down into say, in consultations, patients coming into your rooms, obviously there can be in hospital consultations, you then have to have the discussion with the patient. But in your rooms, have your fees displayed, the most common fees charged, and make them known to the patient when they phone to make appointments. Have your staff tell them this is what the fee will be. It is the healthcare provider's responsibility that patients are aware of these fees, not the patient to ask you. This is in the guideline. Fixed, transparent, and documented billing policy and set of charges. You need to document, according to this guideline, you need to document how you came up with your billing policy. Now, you may decide that you are going to bill according to one of the direct payment arrangements with one of the funders, and that you're going to apply across your practice. That's fine. That's acceptable. But just make sure that that is how it has been decided and that you've actually documented that as your policy. Document how costs are determined. So you may charge different costs to somebody down the road because you might be in practice for 30 years. They may be in practice for 5 years. You may have different skill sets, etc. Keep good records. You need to explain to the patient how the fees are levied. Is it a fee for service, the global fee, and what portion they will be liable for, and what portion the medical aid will be liable for. And you need to discuss all costs. So if you're going to a consultation and there's a standard consultation fee, but you end up doing urine dipsticks and a peak flow meter, or you do a nasal endoscopy, or you do a tympanogram, or whatever might be there in relation to your discipline, you have to tell the patient and get their consent and tell them what the fee is before you perform that procedure. You can't just lump it on the bill at the end and say, oh, everything was there. In procedures, you need written informed financial consent. You need to explain fees for each option and each action. You need to have informed consent is an ongoing process. So you need to keep going back to the patient and making sure that they understand what you're going to do, understand what the options are, understand what fees are going to be charged, and explain all charges. All too often, you end up with a patient in hospital who thinks that the fee they're paying to the hospital is an all-encompassing fee. You need to make it very clear that as a healthcare provider, your fee is separate from the hospital and radiology and pathology and physio and. You need to make sure that's understood. And use the correct billing codes. Don't be creative. Now, if you look at the pitfalls and you look at the fraud, waste, and abuse and error investigations done by funders, the overwhelming majority of investigations are instituted because members of the medical scheme want verification of the services that they have received. So these are member complaints. It is by far the majority. The analytical systems that the funders use to look at coding discrepancies and other elements is a minority of the complaints that they are having to filter through. The number one reason for a complaint is verification of services and items claimed, meaning people are either that they are billing for services that they never told the patient about. I mean, there have even been crazy situations where doctors are billing for services they've never even seen the patient. But if you are seeing a patient and you are billing for something that you haven't done, or you are billing for something you never told them about, they are going to complain. And then in coding, it's incorrect application of the defined billing rules. And usually it's upcoding, incorrect use of codes, and not informing patients of charges. There are lots of finger errors, and these can come up, and those can be picked up, and they usually go nowhere. But it's really important that we understand the codes that we use. As difficult as they are, as problematic as they are, we need to be able to understand them and use them accurately. So essentially, be transparent, talk to patients, and give all the information freely. And it's imperative that we read the booklets and the relevant sections of the Acts. Thanks, Amy. I'll stop there.
Wonderful, Dr. Strawn. Thank you for that very informative opening session. We've got lots of questions coming up, so I think we're going to have a great discussion. Paul, if I can ask you to present. Dr. Strawn, can I ask you to stop sharing on your screen, please? Perfect. Thank you very much. Paul, if I can invite you, please. And you're going to share some insights about the problems that the HPCSA are seeing and why there is now a need for this dedicated Booklet 19. We're looking forward to hearing from you. That's beautiful. If you could share your slide deck for us in presentation mode. Wonderful. Now? Perfect. Handing over to you.
Thank you. Thank you very much, Amy, and good evening to you, the panelists, as well as to everyone on the call. Mine is a very simple task, Amy, to share the trends that have been noticed by the HPCSA in relations to these whole issues of billing. But before I do that, let me just locate these particular guidelines amongst other references. Well, I always say it is important to take note of the Health Professions Act. As a person registered with the Health Professions Council of South Africa, it's essentially the act that makes you and I to be registered with the HPCSA. It's not only giving the structural or governance understanding of your very own organization. This act also has some elements of ethical references that you can pick up. Dr. Simon has already indicated some of them. But most importantly, this act gives authority to the council to develop other subsidiary or secondary references, such as the ethical rules, the one that is commonly referred to as Booklet 2, recently amended in November 2023, with some interesting changes in relations to the health market inquiries recommendations. Sometimes these ethical rules are not very clear for all of us, especially if you are not a legal practitioner. It's not very easy to comprehend all of them. If the situation arises that you pick up some gray areas that need further elucidation or clarity, what often happens is the professional board concerned. If you are a doctor, then you will have registered with the medical and dental professions, gets to explain and clarify in context to how things work in their own space. If it is radiographers, they'll do the same. Psychology will do the same. And this explanation or clarity that the professional board makes in response to ethical rules queries or Health Professions Act is referred to an ethical rulings. And these rulings, I'm referring to them because they form majority of the guidelines that we are speaking about today. Dr. Simon indicated that really that document does not provide anything new per se, because everything that you are finding there is either reference to other legislations or some ethical rules or rulings. Therefore, HPCSA just thought it's important to consolidate this guidance so that practitioners can find it easy and can accordingly make reference to it. This guidelines, Booklet 19, is understandable that majority of the persons who are on the call today were not aware of it, because it's a fairly new document in this format. Although it was scattered everywhere, in this format as a standalone guideline is fairly new. And it is explaining, as I indicated, what is already in the laws somewhere or in the ethical references somewhere, more so in the rulings as well as the rules. I just want to highlight this, that it is important for everyone to be aware that the development of this kind of references may from time to time borrow from other legislation so that they talk to each other, because as you may be aware, all these other legislations, primary or otherwise, they sort of are interlinked. So when you look at this kind of guidelines and you are seeing some references, it may not be necessarily restating them, but it is referencing so that you can have a picture that other pieces of reference, ethics or legal or otherwise, are still talking to the same subject and they are in synchronicity together. Well, sometimes it doesn't have to be legal stuff like legislations, National Health Act as an example, Consumer Protection Act, and the others. Sometimes it may be subordinate piece of legislation from the Health Professions Act or others, such as the regulations that will talk to how ethics should unfold in practice. We try to infuse that into the guidelines to assist. So today, the focus is only Booklet 9. It's not the only booklet that has been developed or reviewed recently. In fact, majority of these 20-odd booklets, I'm saying 20 because I think one more is on the pipeline soon to be published, talking about the issues of AI and so forth. In totality, that will be 20, but otherwise, this is the focus, the issues of billing as a result of all these available references. So why did the HPCSA go this route? Because I'm beginning from 2021. When we look at the trends of complaints against the practitioners, both in public or private, we've realized that these issues of billing has always been at least on the top 3 or top 4 at best of all the complaints that practitioners are being reported to the HPCSA. You can see negligence is 23%, issues of reports relating to Rule 16, 17, but accounts here you see it's about 14%. It's always tops. Same picture you can easily see in 2022. Negligence is still there. Negligence, by the way, it's a negative conduct. It's an omission. What should have been done as determined by objective assessments, the reasonableness test, whatever. You see accounts again, still tops. This is 2022, 3 years from now. 2023, you can still see issues of accounts. They're never far behind from the top. This is one of the troubling issues. Not to say that the other issues are not being addressed, but we thought if we, at this time, focus on the issues of accounts and accordingly advise practitioners, guide them, because essentially that's the mandate of the HPCSA. The mandate of the HPCSA is not to catch you out when somebody reports you. You must be guided accordingly. In order for you to be aware of how to easily navigate when you are practicing. Even financial year 23 are never far off from the troubles that practitioners are finding themselves in. And as such, this format and manner of guidance had to be developed to assist to practitioners to find these into accounts and billings best supported. You can easily match issues of account, informed consent, and billing. They are all related. And if you combine them, you can see even negligence becomes nothing. That is why we thought it's prudent that you get supported and assisted from what you already know, but the easy, clearer, and most best way that we can do as a practitioner supporting the patients. Thank you very much, Amy. That is where I end.
Thank you very much, Mpho, for that very interesting view from the HPCSA's perspective. So audience, we're going to switch over to Q&A session. If I can ask the panel to please put their cameras on, and We're going to start with 2 questions that were raised by attendees who registered, and then we'll kick off with the questions that have been raised in the chat and the Q&A. So, panel, our first question is, can I bill if a patient dies during resuscitation or anesthesia? So, who would like to step
I can.
and offer
Let
something?
me kick off for that.
Thank you.
So let's take the situation where this was a planned procedure and the patient has given consent, both informed and has signed informed consent and financial consent, and that patient then crashes and dies during anesthesia. Because you have consent and you have financial consent, then you are well within your rights to charge for the services that you have performed. You could take that a step further and say, let's say you went in to do, I see there was a question about a hemicolectomy and things going wrong. Within the consent, you're not just obtaining consent, and within the financial consent, it's not just about the planned procedure. There has to be wording and discussion around the fact that things may escalate. There may be issues. And in those situations, you will do what is required of you and that the patient will cover those. So you obviously can't give a financial amount for each of those eventualities. But the point is that you can still charge for them. And if the patient dies, yes, you have your rights to do that. In an emergency situation, now it's difficult because you may have no opportunity to speak to the patient themselves and to get any form of consent from them. There may be a family member or a responsible person with them, but again, in that emergency situation, they may not be in the state to even have a conversation with you, and you may not have the time to do that. You cannot withhold care. You have to go ahead and perform the emergency services. And if the patient dies, because you performed the services, you again have the right to charge for those services. If the patient had survived, you would have then either gone to the responsible person who was with the patient if the patient was then unconscious and not able to give consent, or you would then discuss that with the patient when they were able to. But in the eventuality of a failed resuscitation, the patient dying, yes, you absolutely do have the right to charge. But in those situations, you need to have very, very clear, well-written clinical notes with every action that was taken, timed. You need to explain the resus down to the letter. You need to be able to really demonstrate everything that you did. So that's the nutshell of it. But you know what? You don't have to charge a patient. In those situations, I mean, I have never charged for a failed resus in my career just because I didn't think it was right. I really just didn't sit nicely with me ethically. Ethically may be the wrong word. I just wouldn't sleep at night if I did that. But it's up to you. Obviously, you have the right to charge. Let me stop there and give somebody else a chance.
Thank you very much for that very practical and pragmatic perspective, Dr. Strawn. De Niro, can I invite you to give a legal perspective?
Sure, Amy. So legally, in line with Simon's submission, you do have the right to charge. The claim would fall against the estate of the deceased patient. And obviously, if the deceased patient had medical aid cover, it would be for the executive of the estate to submit the claim through if it hadn't been paid. But to echo what Simon says, just because you have the right to charge legally, you don't have to charge. That's a decision that you can make as the practitioner. And of course, if there's concerns around professional negligence in relation to the manner in which the anesthetic services were performed, that may result in the estate or the medical aid scheme not paying that account, and that will give rise to a potential medical malpractice claim. So legally, you are entitled to charge, but as Simon says, that's a decision you can make on whether to exercise that right or not.
Thank you, De Niro. Shlumbi, I saw you take yourself off mute. Would you like to offer a perspective from your side?
Yes, thank you very much. I mean, I don't disagree with Simon and De Niro, but the only thing that I just wanted to emphasize here is doctor-patient relationship, because it starts there. I mean, if you look at the booklet and most of the questions that are written here, basically, if you take this booklet and you say this is a financial informed consent, just like all the consents that you do in terms of procedures, you will then have an understanding that there will be unknowns, but the patient must not be surprised. I mean, the hemicolectomy question, for instance, or a patient that would have a complication that is really unknown, as long as that patient would have that understanding upfront, that is what is really important. And secondly, in the interest of the patient, remember, like the HPCSA know that, one of the rules is in the interest of the patient, and therefore everything that we do has to be in the interest of the patient. There are questions here that are talking about scheme rules. There are questions here that are talking about billing codes. That's a complex world for an ordinary doctor. That's a very, very complex world. What is important is, I mean, Simon, you've put it nicely. You said clinical records are important. You should be able to say in that informed consent, the financially informed consent, those are raised as the unknowns. There's so many different schemes with many different rules. How do you expect that the doctors will understand all those different codes, all the different rules for each and every scheme that each and every patient would come in? Your protection is in your clinical notes, in the informed consent, financially informed consent that you have. Therefore, I don't disagree in terms of billing, but your saving grace really is your notes and a comprehensive informed consent or financially informed consent form.
Thank you, Shlumbi. Dr. Strawn, I can see your hands up. Would you like to add something further?
Yeah, I just wanted to, Shlumbi gave a good segue into many of the kind of the nuances of many of these questions around, and what they're really referring to is, we have patients in hospital where you can have patients lying right next to each other with exactly the same condition, being given exactly the same treatment. And because they're from a specific medical aid and on a specific option, you have to charge them at different rates. Is that allowable? So from my perspective there, if you have signed up as a direct payment arrangement with the medical aid, it means you as the healthcare practitioner have contracted to charge that scheme rate for that option for that patient. So you are then right in line with what the patient's expectations of you are. They're not going to be out of pocket if you charge those scheme rates. So that's the first point about it. So it can seem like it's strange, and you may go, well, that's ridiculous and seems unethical. But the point is, the patient is the person you're dealing with, and you have an agreement with their medical aid to charge them that. And in those direct payment arrangements, you can't now demand a co-payment. So in that situation, you are doing the best you can for your patient, and your patient has that expectation. There was a question about above what level must we tell the patient what exceeds usual fees, referring to the Health Professions Act. Now, the current HPCSA guideline does not refer to that. The current HPCSA guideline doesn't refer to the Health Professions Act. It actually says you need to discuss everything with your patient, not if they're just above your fees. You have to tell them everything, and they have to understand that. And I think that's the way we need to be doing this. I think it is very dangerous to take a position and go, well, these are my fees. I'm not actually going to tell my patients only if they ask. I think you're opening yourself up to problems in with that. And the last point I wanted to make was within the guidelines, it says you need to have a documented billing policy, and that to use national benchmarks is acceptable. So it is not unusual for many doctors to be signed up with many direct payment arrangements, and each direct payment arrangement will pay different percentages of that medical funder's scheme rates, which means there will be differential pricing. But if you have a patient who comes to you from funder X and you have signed a direct payment arrangement with that funder X, that's what you tell the patient. That's your billing policy. You include that in your billing policy. We are signed up we are contracted in with the old terminology. We are contracted into. So we have a direct payment arrangement with this funder, this funder, this funder, this funder. And if you come there and you don't belong to any of those funders, then that's your billing policy. That's the way that you manage this.
Thank you, Dr. Strawn. Paul, I can see you've taken yourself off mute. What would you like to add?
Just to add a bit on what was said, this particular guideline, it is not providing any references to a tariff or rates that a practitioner uses to get reimbursement, intentionally so, because that is left to the practitioners to make that determination. So the policy is open to you as a practitioner. Which ones do you follow? As long as you are doing it transparently so with your patients, you are consistent, and you have got some documentations to indicate which ones are you preferring, that is up to you. That is intentional. It is not attempting these guidelines to draw some ceiling on which rates can be used. You will choose which ones are nationally acceptable, and then you will follow that. Thanks.
Well, thanks very much, Paul. There's another really good question that came up more than once for those that were adding questions in the registration process, and that was, can I charge a patient who doesn't pitch for an appointment? So who would like to step in and offer a perspective first? Shlombi, I can see you chuckling there. Can I invite you to give a perspective first on this one?
No, it's a question that I really like, because I mean, we deal a lot with lawyers. I mean, I say this all the time. You know, lawyers will charge without thinking. They will charge, you know. And also, I mean, from a clinical perspective, yes, you can charge. I think the guidelines are very clear that you can charge for, you know, a patient who doesn't really honor, because I mean, you book an hour for this patient, the patient is not there. However, you've got to be thinking about what Simon is emphasizing here, I think, in his presentation. You have a relationship with this patient. It's a doctor-patient relationship. And in your billing policy, it's got to be very clear, when do you need to cancel your appointment? If you cannot cancel that appointment for some reason, maybe it's practical to think about it, discuss with the patient, do all you can to see if this patient was able to come or not to your practice. But in general, charge, but practically, you know, you want to keep the doctor-patient relationship at its best, unless these are repeat offenders. Then repeat offenders, you've got to try and do something about them.
Dr. Strawn, I saw you take yourself off mute first. So do you want to pop in here, and then Paul, I'll come to you?
Yeah, okay. So if you look at the descriptors around charging for, and there is a code in the South African Medical Association, a Medical Doctors Coding Manual. It says if the appointment was not cancelled within 24 hours for specialists or 2 hours for GPs, I think is correct, and there's a no-show, then you can charge for that. Now, the reality is that no funder will refund you that. No funder will pay you that. The funders don't accept that. Then you have to go to the patient. And I can tell you that if you do that to a patient, you'll never see them again. So if you want to lose a patient, that's the best way to do it. And the other thing about this is, you know, we run late sometimes, and patients have to be rescheduled, and they've missed a day's work, and not being able to see you. So I think we need to be very, very circumspect in the way that we approach this. We need to understand that the patient may not arrive for a reason outside of their control. So if you're really of the opinion that you are going to drive this in your practice, I really think that you need to contact the patient, make sure that there was not a legitimate reason for them not attending, make sure that they understand that they will be liable. Honestly, in all my years in practice, the best thing to do when a patient doesn't pitch is get up, make a cup of tea, enjoy the time that you've got, take a breath, do something else, and see the next patient. I really don't think it's worthwhile. If you want to, at the very worst, put a mark on the patient's file and give them 3 strikes and they're out. So if they come 3 times in a row late for an appointment or they don't pitch, the next time they phone for an appointment, you can say to them, we have decided that this relationship is no longer conducive to us, and we're going to refer you to somebody else. That's the way I would handle it.
Thank you very much, Dr. Strawn. And Paul.
Yes, thank you, Amy. Just to again extend the point, the timelines that the Professional Board for Medical and Dental at the HPCSA have resolved on in order for the missed appointment to be charged. GP is 24 hours and the specialist is 2 hours. So practitioners have to be cognizant of those timelines. That's very important. Number 2, you are not charging for services not rendered when somebody don't show up. You are charging in terms of the Consumer Protection Act for missed appointment. Somebody accepted that you will give them services or goods at this particular time in line with Section 7 of the CPA, and they don't come. And when they don't show up, then you are they are liable to reimburse you. It goes both ways, as Dr. Hlombe indicated. If you don't show up, the patients at the same time, Consumer Protection Act is protecting them to say if they can quantify whatever they have lost by you not showing up, then they can seek restitution. So I fully support what Dr. Simon indicated. If it goes both ways, you don't want to be paying somebody for not showing up for reasons that are beyond you. Same your patients. It's better you go and have a cup of water and not charge them so that they can reciprocate the next time. So it is not contravention of Ethical Rule 7 for that prohibits you for charging for services you're not rendered. You are just using a CPA if you are interested in going straight to their pocket. Thanks, Amy.
Thanks, and Paul. De Niro, I can see your hands up. What would you like to contribute?
Thanks, Amy. So if you are going to go the route on charging, just make sure it forms part of your billing policy or your terms and conditions. But more importantly, that's communicated to the patient. Don't have it hidden or in small font in some section. It must be clearly conveyed that that's your billing practice and what would be the outcome in those circumstances. It might be useful if you don't want to set that as a strict rule to perhaps say you retain the right to charge, because again, there may be legitimate reasons as to why the patient didn't pitch. But in short, just make sure that it is part of the policy. It's in simple and plain English, and it's highlighted to the patient in the first engagement so that everyone is clear insofar as that billing policy is concerned.
Wonderful. Thanks for that clarity, De Niro. So I wanted to check in with the faculty. What do we think about moving towards one of the cases and do a case study? Everyone in agreement? We'll come. There is another Q&A later. Okay. Tech team, if I can ask you to get ready, I'm going to put up case study number 1. All right, so let's start with case study number 1. So this is an opportunity for you as an audience to vote and give us an opinion. There will be a little poll. It is anonymous. For those of you who struggled at the beginning, I'm hoping that is now sorted. You are welcome if you struggle to just put your answer in the chat, and I'll have a look at that as soon as we have closed the poll. All right, so case study number 1 is Dr. Patel is an orthopedic surgeon. He consults with Mr. Glamini regarding a knee replacement surgery. During the consultation, Dr. Patel provides Mr. Dlamini with a general overview of the surgery, but doesn't discuss the estimated cost or whether his medical aid will fully cover the procedure. Mr. Dlamini proceeds with the surgery only to receive a bill of 85,000 afterwards, with his medical aid only covering 55,000. Upset about the unexpected 30,000 Rand shortfall, he files a complaint alleging that he was not properly informed about the financial implications of the procedure. So the question to the audience is, which of the following best describes Dr. Patel's ethical violation? A, he used the incorrect billing code. B, he performed an unnecessary procedure. C, he failed to obtain written and informed financial consent before the surgery. D, he engaged in split billing, which is prohibited. Or E, he overcharged the medical scheme. Dane, Marcel, if I can ask you to please bring up the poll for case study number 1. Thank you very much. If I can ask the audience, please, to vote. You can only vote for one option. It is anonymous. I'm noticing that some of you are putting answers in the chat. That's no problem. If the poll's not coming up for you, we will close that in due course. So I'll give you a few more seconds to vote. And I just want to check my answer here so that I'm ready for you all. All right. Okay. Dane, Marcel, please could you close the poll for us? And let's see what the audience feels. So the audience feels that he failed to obtain written informed financial consent. 95% of you who voted on the poll agreed. And I'm going to tell you all that you were right, which is wonderful. So I'm going to close this. I'm going to stop sharing. And I'm going to go to the panelists. As panelists, what would you like to highlight in that case? Dr. Strawn, I can see you nodding. Do you want to kick off?
Yeah, so I think that in a situation where the patient was wholly and solely responsible for the bill, suggesting then that they were not on a medical aid, for example, then clearly the infringement there was that there was not sufficient information provided and there was no written informed financial consent. So that makes sense. And I think that's fairly straightforward. What's interesting, though, is if Dr. Patel, the doctor mentioned in this scenario, had signed a direct payment arrangement with the medical aid, and the medical aid fee was 55,000 Rand, and the direct payment arrangement with the medical aid said that he may not charge a copay, then the last one may be right in that he did overcharge the medical aid. But what the point is, though, that he may not then claim that as a copay from the patient. I think this is a really important question because I think this is how the majority of people are practicing at the moment with their medical aid patients, is that there's an assumption that the patient must understand what scheme they're on, and the patient must understand what option they're on, and they must understand what the copay will or won't be. They bought it. It wasn't us. Well, these guidelines are suggesting contrary, that it is the healthcare professional's responsibility to ensure that the patient is fully informed, that there is informed written consent, and that you've discussed the relationship between what you will be charging and what their and the medical aid's responsibility will be. So I think those are the important points.
Lovely, Dr. Strawn. Who else wants to offer? Mpho, I can see you've taken yourself off mute.
I think the point that gives the practitioner the obligation to be the one dealing with issues between them and their patients is because the Medical Schemes Act refer to them as a service provider. You are providing healthcare services, but at the same time, you are the one who is in liaison in terms of financial issues between the medical funders and the patient. And as such, you cannot provide, as Dr. Patel in the scenario, a surprise billing to somebody. They don't know about it, they receive it, it's too much for them. That is the reason majority of practitioners end up now having to justify with the regulators. Thank you.
Thank you for also sharing that perspective from the HPCSA, Mpho. That's really helpful. De Niro, Shlumbi, anything you want to add at this point? Shlumbi, I'll go with you first.
Yeah, these are complex issues. I mean, from a case study point of view, it's easy because I mean it's something that is written. I mean, we really do not have a clearer understanding as to what happened to the doctor. What if they were, they spent, as an orthopedic surgeon, spent 12 hours there, and there was a Doppler that they needed to do that was not actually there. I agree that firstly, it's all part of the financial informed consent. The unknowns, that for me is the most important thing. And I must just say that, look, the focus on the medical schemes and the medical schemes rules and the benefits and all of that, I know from a fact that it doesn't sit well with most doctors. Because at the end, the same HPCSA would go back to the doctor and to say, in the interest of the patient, the professional rules are these. Therefore, we must try and balance the practical side of it, rather than really sticking to what is written in section what of the guidelines. But there's a practical side to it. But the bottom line is that if we were to give a very simple answer, it's a detailed financial informed consent. So we agree with the audience. But it's not as simple as that.
Thank you, Shlombe. De Niro, do you want to pop in here? Are you good?
Good, thanks. But just to reiterate, I think compliance with the guideline is the starting point. And we now have it codified that you should have written informed consent insofar as billings and financials. And you wouldn't find yourself in the situation. So stick to the guidelines.
Wonderful. So I'm seeing some questions that are coming up in the chat here that have just come up that seem to be linked to this case. And I'm thinking maybe we should pick up on some of those. The last 4 questions in the chat. Everyone in agreement? Can I choose? Happy. All right. So what about this one? Why is it not appropriate for a patient to co-pay when the medical aid pays at least something for what is claimed? For example, they've mentioned here for psychotherapy, they simply reject it when there are funds available. Someone want to answer that?
Yeah, I've been looking at these questions, and Amy, I think they're quite technical for tonight's discussion.
Sure.
It does highlight that there are many billing issues that are important. Here we're talking more about an overall guidance about how to implement billing and what you need to maintain within your practice. But actually, I was writing on my little piece of paper next to me. There may be scope for another webinar where we actually delve into these specific billing issues, because when you delve into something like the question you've asked, it actually can, in a very short space of time, be quite encompassing of many other questions. And I'm just a bit scared that if we get caught in this, that we may miss out on the real opportunity of tonight. So I'm not discounting the question. I'm just not entirely sure that getting into it tonight is the right forum.
I'm perfectly happy with that. I've made a note that potentially we must come back for a specific billing webinar focus. Is there another question maybe in the chat that you feel would be more appropriate to discuss? The last, let's say 5 or 6 questions that have just popped up in the chat. Is there something there? If not, we'll go to the next case.
Yeah, I think just one of the things that's come across for me is that, and I think Mpo highlighted this earlier, there is no reference in this guide, and we are definitely not talking about what percentage you can charge, what you charge, that is your discretion. The critical thing here is you must be able to defend your billing practice. You must be able to demonstrate that your billing practice is rational. You must be able to demonstrate that your billing practice is transparent and that it is utilized coherently and consistently. So if your billing practice is that you charge for this funder this and that funder that and cash patients, if that's your protocol and you can defend it, then do it. That's okay. Is it ethical that you charge one patient this and one patient that? Your ethical responsibility is to give the treatment to the best of your ability and to charge the patient the contract that you have with that patient. That's it.
Thank you for that clarity. I've seen a question come up. Yes, sorry.
Maybe just Just to add on what Simon is saying, I mean, it seems like the discussions that we have here, they are almost always talking about medical schemes and all of that when there are cash-paying patients, where you need to be clearer. I mean, that becomes simpler. We've got a lot of specialists that, they do a lot of work where you need to be paying cash. So we must not also just focus only on medical aids, but there is that in financially informed consent should also be as consistent as possible for your cash-paying patients.
Thank you, Shlombe. Paul, I can see you've come off mute.
I just want to say, medical funders and medical schemes are also regulated by the CMS, as we all know. It does not mean that if they reject a claim, it's a golden rule that must just be acceptable as such for everyone. There also has to be questions as to their conduct, and their regulator can explain more. If you understand how you are contracted with them, how they are contracted with patients, and you are saying, oh no, something is just not, they are also entitled to justify to you as a service provider why they are not honoring your request for such reimbursement, because you would have done the service already. Thanks.
Thanks, Paul. So there are two, I think, simple questions that I think maybe other people are also asking. So one person has asked in the Q&A, does financial consent need to be done by the practitioner directly, or can it be done by the billing officer in your practice? Someone want to offer a comment there?
I think this is up to Nero's alley.
Okay, De Niro.
Yeah, I think it would be preferable for the practitioner to have the conversation, not the billing officer. And I think, again, if there's a complaint made against you, if you one party to obtaining the informed consent, you're going to find difficulty in defending your position. Now, practically, there may be issues around it, but I think safeguarding it, the responsibility is yours to obtain informed consent. And it's not something when it comes to the actual risk of a particular procedure or treatment that you defer to somebody else. So I would think that when it comes to it, particularly in the initial engagement with the patient, that you do it yourself. You may defer certain aspects of it to your billing officer, such as invoicing and when payment is due and those sorts of things. But the actual nuts and bolts of how you charge, how you bill, it would be preferable or advisable that you as the practitioner have that communication and obtain that informed consent with the patient directly.
Thank you, De Niro. Okay, one question that I've picked up in the chat that I think may be helpful to many people in the audience is, who is responsible for telling patients in hospital how much their path will cost, like bloods, urine, etc.? Anyone want to offer a perspective there? Dr. Strawn?
Yeah, I think that the responsibility of the healthcare professional is for their own fees, and for it to be made clear to the patients that the other fees are separate from their fees. I think that's what your responsibility is. If you are planning to do a whole lot of tests for which the patient may be liable, well, then the patient can get that from the lab or from radiology. I mean, we do that all the time. That's how we do it. I don't think that there is an expectation here that every single blood test that you do is costed. I don't think that's your responsibility as a healthcare professional. I think it's your responsibility to say to the patient, there are other costs, and these are the people who will be doing it. And when they come to do it, you can ask them.
Thank you very much, Dr. Strawn. And Paul, I can see you've taken yourself off mute. Do you want to jump in there?
Yes, Amy, practitioners in charge of their own processes. Hospital authority or any other entity hierarchy must develop policies that will inform patients about other things outside of the direct practitioner's control. It's not, practitioners not in charge of everything. Is in charge of that of which is required between them and their patients. Thanks, Amy.
Thanks, Paul. Shlombe, last comment.
Yeah, I just wanted to add just one thing there. That is, what we see is that patients tend to think, well, they know that the relationship is with the primary doctor, and anything and everything that goes wrong, it starts with you, the primary doctor. As much as it is not your responsibility, but it is your responsibility to inform that there are known costs, there's pathology, there's radiology, there's anesthetists for surgical procedures. Because we see that they would ask, why am I being billed by that person when I'm supposed to be billed by you? So it's something that it's got to be very important to understand that you have the accountability. You must inform the patient. And the best thing to do, as we've been saying, you need to be writing your clinical notes as detailed as possible.
Thank you, Shlombe. So, De Niro, do you want to pop in here quickly?
Yeah, I just saw one of the comments in the chat section. Yeah, is it Ronaldo?
Yes.
Yeah, just to respond to that, I am talking about financial consent. Remember, the guideline is not for your secretary or your receptionist. The guideline is for you as the practitioner. And the guideline is specific. And guideline 5.1 and 5.2, the health practitioner shall in writing receive informed consent. So that's why I'm saying it's not something you want to defer. You want to be confident that if you called up or challenged on whether you did get informed consent insofar as financial consent is concerned, you had the direct conversation with the patient. So I would say, have a look at 5.1, and that's what you should seek to comply with.
Thanks, De Niro. What I also wanted to check is that would a practitioner be correct in putting it in their clinical notes? I have spoken with Miss Amy Wolf and about informed financial consent and the proposed costing, just documenting it.
Well, I mean, I would think that you would follow the form as you had done with your procedure or treatment informed consent form. So you would have it documented. You may have a standard form where you have a discussion, and then you could tick off in a box or how you would put your standard form, and then get the patient to sign that. Now that stands as documentary proof that the discussion took place. It doesn't have to set out in detail what the discussion was, because you would then, if being challenged at HPCSA or in the court, you would say, that's my standard form. That's the conversation I would have had as a policy. I can't remember each and every patient over the last 5 years. So that gives you a bit of comfort that you had the conversation, the form was signed, and it would say, patient had conversation with Dr. So-and-so. So I would say mirror the way you get the written informed consent for your procedure or medical treatment, just to cover yourself. Because again, as we know with court cases, you're in the witness box 5 years down the line, you're not expected to remember each and every patient that you treat.
Thank you, De Niro. Panel, should we go to another case? Let's see. Sure. Okay. So tech team, if you can get ready. Right, we are on case number 2. So case number 2, audience, is Dr. Sifiso Ngema, a gastroenterologist, charges 12,000 Rand for colonoscopy. Ms. Jacobs, a medical aid member, is informed that her scheme will only cover 9,000 Rand, leaving her with a co-payment of 3,000 Rand. However, Dr. Ngema only provides the medical scheme with a bill of 9,000 Rand while issuing a separate invoice for 3,000 Rand for the co-payment to Ms. Jacobs. She later learns that the split billing practice is unethical and reports Dr. Ngema to the HPCSA. So the question to consider is, what is the primary issue with Dr. Ngema's billing practice? A, he failed to disclose the co-payment to the patient. B, he engaged in split billing, which is unethical. C, he overcharged the patient for the procedure. D, he refused to treat the patient without upfront payment. Or E, he charged an incorrect billing code. Tech team, can you please bring up the question or poll for case study number 2, please? Thank you very much. If I can invite the audience to please vote. You can only choose one. For those of you who are struggling with voting in the chat, please put your comments. We'll have a look at those. So which option would you choose? All right. So 81% of you believes that he engaged in split billing, which is unethical, and 16% chose he failed to disclose the co-payment to the patient. Right, thank you very much. I'm going to stop sharing and go back to the panel. And I can see some answers coming through in the chat. Thank you, everybody. Who wants to start with a comment? De Niro, wonderful.
Yeah, so split billing is not an acceptable practice as recorded in guideline 9.5. So that's a specific response which your poll reveals that our attendees are aware of. So just as a reference point.
Wonderful. Thank you very much for that observation. Dr. Strawn?
Yeah, I think the important thing is, yeah, the other thing is that there's no problem in charging more than what the medical aid charges. So the fact that there was a 3,000 Rand excess, that's not the problem. The problem was that it was presented in a split billing fashion. That's the first thing. The second thing was that if the diagnosis was a PMB, you can't, in terms of PMB regulation, you can't have the patient pay a co-payment. If you have a direct payment arrangement with the medical aid, and the contract with the medical aid says there can be no co-payment, you can't charge the patient the co-payment. But in all other situations, if you say to the patient, this is what your medical aid was going to pay 9,000, I'm charging 12,000, you present the 9,000 and 3,000 on one bill, the medical aid pays their 9,000, the patient pays the, no problem. So it's really just understanding the relationship that exists between those and what split billing is.
Dr. Strawn, and maybe I missed this in your explanation, but we've got someone specifically asking for clarity on the difference between split and balanced billing. Who would like to offer a comment on that? And if you have answered it and I missed it, please just tell me and we'll move on to the next one. De Niro.
I think someone answered that in a sense that basically the guideline says if the total for this relationship, it's 10,000 rands. So both the medical aid and the patient must get the 10,000 rand bill. However, the medical aid might have paid 7,000 and the patient must have paid 3. That is what is expected here. And that's balanced billing. Split would be sending 7,000 to the medical aid separately and 3,000 to the patient separately. Is that simple enough? Is that correct? Remember, I don't do billing at all.
That's beautiful for a layperson like me. And thank you for the practical example. Thank you, Shlombe. That was great. De Niro, I can see your hands up.
And you can see Shlombe is obviously not the lawyer because for the reference to the definition section of the guideline, it actually defines balanced billing and split billing. So, I would advise the attendees again to have a look at it. Again, there's been a comment that split billing is not unethical. It's undesirable, but not unethical. I'm not going to debate whether the guidelines are open to interpretation. But I would think that if the guideline is saying it's an unacceptable practice, rather stick to complying with the guidelines to avoid getting yourself a complaint where you now have to answer. If you want to debate that issue, then I think do it through the proper channels. But until you get the clarity that you seek, refer back to the guidelines and comply with the guidelines.
Thank you, De Niro. Appreciate that. Paul, I saw you come off mute. You want to offer?
De Niro is going to start being a proper lawyer and address us on undesirable versus unethical. But it's absolutely correct. I think the guidelines goes to an extent try to clarify the two concepts. In this scenario, if we just go back, it looks like nothing is wrong because the balance tally to the original amount. But imagine a situation where 8,000 is going that side because the bill is not referencing the other 8,000 is going, which will make the total amount now eventually be more. So I think the concept of split billing is trying to assist everyone to look at the same bill so that we mitigate against temptation where you can eventually receive more than what is due to you. I think that is the whole arrangement with the split billing being prohibited. Thank you.
Thank you, Paul, for that clarity. Anyone else want to offer something? Dr. Strawn?
Yeah, I'm just seeing there are two questions around taking co-payments in your room. One for an initial levy fee of opening a file, okay? And the other is charge a co-payment in a room before submitting to medical aid. So again, if there is no arrangement with the medical aid, then sure, you can do that. But all that is being asked is reflect all of the money received and the charges asked and the charges and what you've charged on the bill, on the statements. Don't leave stuff off the statement. Reflect all of the transactions that have happened. That's really what it's about. How you get that money and what you charge for, that's up to you. But just make sure you've got consent for it and that it's all on the same bill.
I've got a question that's just come through on the Q&A, which I think may be helpful and maybe simple enough for us to cover tonight. How does one collect global fees even before some services are not yet rendered? Is that simple enough for tonight? You want to ask for some additional clarity?
I'm wondering if it's a question or tell me how to do it.
Okay.
I'm not entirely sure because global fees are preset fees.
Yeah.
So they generally aren't going to be paid before the procedure happens. You're going to have to submit an account for that. And then the global fee will be paid by the funder or by the patient if it's a cash patient. I think that any fees, I think that the instances in which fees can be charged before services are rendered are clearly laid out in the guideline.
Thanks, Dr. Strawn. Shlombe, to you.
I was just going to say, because we do get a lot of questions and some very difficult engagements with doctors when it comes to global fees. Obstetricians, for instance, where the patients would complain that you missed the labor, you arrived very late, but you've already been paid. Why, did you have to be paid that amount? It's again one of those things that goes back, because remember what we're talking about here, we're talking about the financially informed consent. If you know that you are an ONG or you are any practitioner that actually gets the global fee, it's important to ensure that that patient understands what is meant by a global fee. Because some of them, they would say, I didn't see this patient, I just delivered. And the answers that we get is, no, that global fee covers you up to 6 weeks postpartum. So it goes back to the details that you need to put in the financially informed consent. That would include if you are a practitioner that really gets the global fee.
Thank you, Shlombe. Paul.
I think the two speakers have already said what I wanted to say, but just to emphasize, Ethical Rule 7 prohibit receiving fees for services that have not yet been rendered, irrespective of whether you are using a traditional fee-for-service model or any other alternative business arrangements. Receiving that money for services that you have not or are yet to deliver is just prohibited. Thank you, Amy.
Thanks, Paul.
Amy, are we allowed to ask
questions? Of course you are. Yes, please.
What happens, Paul, in a case where you've been hit once or twice in this township, where people just disappear and they don't pay, or they would say, "Oh, I didn't," and what happens in those cases? They just disappear, or they don't pay, and you've already delivered the service, or they run away with your money that has been paid directly to them by someone else.
Thank you, Dr. Thombe. Can I proceed, Amy?
With pleasure. Yes, please.
I think Dr. Simon in his presentation has already addressed this to say if you have delivered the service and unfortunately for a reason or the other, you are not able to recoup what is due to you in terms of reimbursement, you are supposed to follow a legal debt collection processes so that you can recover. taking the money as an assurance before you deliver the service is what is prohibited in terms of our ethical rules. But the channels are open for you to get somebody else to do the chasing on your behalf if, unfortunately, the township guy is not meeting his end of the bargain. Thank you.
Thank you very much. Panelists, what do we think about keeping with the Q&A? Do you want to switch back to a case and see what the audience knows? What do we feel? Should we do a case? Okay. So let me share my screen. Okay, tech team, if you can get ready, please, with case number 3. Oh, sorry about that. So case number 3, Dr. Buerta, a cardiologist, has an arrangement with a local private hospital where he refers patients for cardiac tests. In return, the hospital pays him for a referral commission of $2,500 per patient. A patient, Mr. Satorli, later finds out about this arrangement and reports Dr. Buerta to the HPCSA for engaging in an unethical financial incentive. Question is, why is Dr. Buerta's practice of receiving a referral commission unethical? A, it violates the ethical rules against perverse incentives. B, he's charging patients higher fees than allowed. C, he failed to inform patients of the cost of the services. D, the hospital should be paying him a salary instead. Or E, he's engaging in an unlicensed medical practice. Tech team, if you can please put up the question. And audience, if I can invite you to please answer. You can only choose one. The answers are anonymous. If you cannot answer, please put in the chat. We'll have a look as soon as I take the poll down. So why is Dr. Buerta's practice of receiving a referral commission unethical? 90% of you believe it violates the ethical rules against perverse incentives. That is on the online poll. Let me just stop sharing here so I can see the chat. Okay, we're seeing some answers come through here, which is good. Right, who wants to kick off the panel discussion?
I was just gonna say, sometimes we use these words and we think we all understand what is meaning. What is meant by perverse incentives? Maybe I should ask either De Niro or Mpho.
Oh, that's a good question. De Niro, would you like to offer a perspective there?
Let me defer it to the HPCSA.
With pleasure. Mpho, over to you.
There is a guideline that talks about issues of perverse incentive and related matter. In fact, it is being considered tomorrow for revisions. Maybe in future, you may want to to have a session that sort of talks to this one. I think in general, the understanding and issues relating to perverse incentive is any deliberate and desire to behave in a way that is unreasonable and unacceptable. So if we are talking about perverse incentive, so you are receiving incentive or reimbursement that is not due to you, that is not desirable ethically to be received by you. I think that is my layman understanding of what perverse incentives is talking about. Thank you. Maybe before I even step out, relating to the scenario, it's not allowed to either give commission or to receive commission in terms of ethical rule 1.2. So I think majority of people here are already in tune with what the rules are saying about this issue. Thank you.
Thank you, Mpho. De Niro, I can see you have an opinion you would like to share.
Yes. So again, the guideline is quite clear on this. I think with reference to 3.31, it sets out, because this would qualify as a commission for a referral effectively. So it's quite specific. So dropping the word perversive is fine. I think it's in substance, it's dealt with in 3.31 of the guidelines.
De Niro, before you pop off, many people I know didn't even know that the HPCSA Booklet 19 existed. Do you maybe just want to give us some key points on what a perverse incentive could look like for those who are looking to orientate and get clarity? Do you want to come back? Oh, there we go.
Yeah, again, I think 3.31 deals with it specifically. For example, 3.31A says, accept commission or any material consideration from any person or another practitioner in return for the purchase, sale, and supply of goods. Pay commission or offer any material consideration to any person for recommending patients. So, I would, again, the idea behind this booklet, as Mpho had mentioned to me the other day, is to effectively put together a guideline on rulings that the HPCSA have made over the number of years. And this has been the practical understanding of what practitioners should do. So this is effectively a codification of those rulings and practices. And again, I know it's difficult, and professionals across the board, particularly healthcare medical professionals, don't have time to go to the HPCSA website and start reading outcomes of cases and penalties and that sort of thing. But it's in your interest to read these guidelines and these booklets as a starting point. You do it in your field. The lawyers do it with judgments and legislation. Engineers have to do it in their field. So when these booklets are published, even beyond a webinar like this, as your lawyer, it's not one of those ones where ignorance is bliss. It's called a guideline, but in fact, it is a set of rules that you're going to be held at a standard if a complaint is made against you with the HPCSA. Again, whether I agree with it or not, well, don't be the practitioner that I represent to find that out. Rather read the rules and know that compliance is going to keep you out of trouble.
Thank you, Dinero. Dr. Strawn, would you like to offer something at this point? Maybe?
Yeah, I just think it's, as a practicing healthcare professional, you kind of know what's perverse. You know when you're getting something you shouldn't be getting. You know when your palm is being greased, when you're getting a shekel in there that you don't deserve. You just need to stay away from those. But back in the day when I started in private practice, I used to get a percentage of every patient I admitted to hospital. That was standard practice back in the late, when I started practice, back in those days. Now not. And you know what that is. So, I think that's what this is about. So, yeah.
Thanks very much, Dr. Strawn.
Yes,
with pleasure, Shlombi.
Just want to follow up on what Dinero was just saying about understanding the various booklets. There's a question here that was asking, can EthiQal provide a financial informed consent template and all of that? I think it is an important aspect that we must understand that we've got all the various booklets. And I mean, Simon has mentioned that, it's the context of your practice will determine how your financially informed consent would be like. Therefore, to provide, a very strict template may not be relevant to your practice. The best template is the one that is written in booklet 19. I know that at the beginning we spoke about, there's a document that we're going to release, but that will not be the financially informed consent. It would be just the highlights of what is in booklet 19. So the responsibility must really go back to us or to the practitioner to ensure that the context of the practice where you are and the compliance to the booklet, that is what is very important. I was just following up on Dinero's reading the 89 pages and the 140 pages of judgments.
Thank you very much, Shlombi. And I've also seen that question raised quite a few times. Dr. Strawn.
Yeah, just scanning the questions here. I just want to clarify something, and Mpho, you can come in here as well, about when are you able to take payments before you render services? In other words, call it a co-payment or anything else. And the three instances in booklet 19 where it says clearly that you may take a co-payment. The one is where it is a foreign patient who is coming forward to accept services and you can charge them. The second is where there is a copay from the medical aid due, where it is stated upfront that the medical aid will not pay all, and there's a copay that the patient may pay. That may be taken upfront. And the third is when you're using prostheses. So I saw a comment about plastic surgery. So if the plastic surgery is being performed and it requires a prosthesis or prosthetic or whatever, you can charge for the prosthesis. You can't charge for the whole surgery, but you can charge for the prosthesis upfront. Those are the three instances in the booklet where it says you can take payment before services are rendered.
Thanks very much, Dr. Strawn. There's a question that's come up in the Q&A that I think may be pertinent for us, specifically about perverse incentives. So this is from an anonymous participant. They say, are corporates allowed to employ doctors, and is that not open to perverse incentives? How are we to interpret the planned change to Rule 18? And what is the current situation versus the possible future? Anyone give some perspective on that? Dr. Strawn, I can see you potentially smiling behind there.
I'm just going to deflect this on to Mpho.
Okay, perfect. Mpho, what's your perspective?
That is not part of Booklet 19, but I can give the status account of what is happening regarding Rule 18. In summary, remember Rule 18 speaks about professional appointments or employment by non-registered entities, both natural and juristic personalities. For example, if Hospital X wants to employ a doctor, that is where the application of Rule 18 comes in. For the last 25, 30 years, plus minus, it has always been understood in terms of Rule 18 that those non-registered persons or juristic persons, when they wish to employ a registered practitioner, they will have to seek approval first before such a prospective employment transaction occurs. In November 2023, when the rules were amended, as a result of the health market inquiries, people were saying, those rules are too flexible. We need to adjust and improve the way in which we do things, innovate, and so forth. Rule 18 was also changed. The only significant amendment on that Rule 18 was the withdrawal of that process of appointment having to come first to the HPCSA for approval. So the authority now for that transaction to occur or not was left at the discretion of the practitioner themselves. Well, many entities after that promulgation came forward and said, maybe this is not the best. The HPCSA, please continue to do what you've been doing for the last decades. Then the HPCSA listened and said, maybe we need further consultation with our practitioners as the main stakeholders. In the interim, let us withdraw Rule 18 latest version. And now, as I speak to you, we have published in the Gazette the intention to withdraw the latest version, which did not have the approval process by the HPCSA, and we want to reinstate the older version of the rule so that we can proceed with consultation. That is the status of Rule 18, and that is the best I can give as a response. Thanks, Amy.
Yeah,
wonderful.
thanks.
Thank you very much.
Yeah, thanks, Mpho. That is a very important answer, and it's the question we've been grappling with is, when are you going to gazette that the rule has been rescinded and there's now a chance for consultation? So thanks very much for that. That's very good news that we can proceed with good consultation on that.
Wonderful. Panel, I am noticing the time and it's now 8:15. How do we feel? There's still some questions or comments that we want to make. Are we ready to wrap up? Mpho? See, you've come off mute.
Unfortunately, having to go somewhere by 20 past at least, if you can allow me. Thanks.
Thanks, Mpho. Dr. Strawn, what's your feeling?
No, I think I've been scanning as fast as I could. I think in general, we've covered just about all of the questions sufficiently. There were one or two here and there, but a lot of it is billing specific. I'm happy that we've probably covered enough.
Okay, thank you. Shlombi, De Niro, what are your thoughts? We ready to wrap up?
Yeah, I'm happy also that I think we've covered enough, especially now that we know that there are many other questions that may need to another webinar, another discussion that may even be
Perfect.
broader than this one. I believe that, you know, at least most practitioners now, they know that there is a guideline or booklet 19, which
Perfect.
basically was the purpose of the webinar. But going forward, we will have to address some of the questions that may go a little bit beyond just what is in the guideline. So I'm happy to end it here.
Wonderful. De Niro, I'm also seeing a
And
note
the
from
sugar
you.
levels are low.
Yes, agreed. It's dinner time. So just to orientate the audience, Dr. Strawn is just going to do a wrap up of 3 or 4 points on his side. I'm just going to do a thank you. And then if you guys would mind waiting, we have an evaluation that we'd love some feedback on that will come as soon as the webinar closes. So Dr. Strawn, can I hand over to you?
Thanks. Amy, I just saw a number flash up, 673 participants. What was the what was the top number? What was the number we had?
I think we were 702, 705 at the top.
Okay. Yeah, I think this is significant. You know, I think what is significant is the number of people who engaged, the willingness to engage, the types of questions, the in-depth granularity of questions. And this is from people who've been in practice for more than 15 years. You know, it just shows the complexities that we're grappling with. And I think that the important points here for me are, you know, it's essential to take your patient on the journey and just be aware, always put yourself in the position of the patient and say, if I were in this position going through a treatment, what level of information would I need? How would I like the financial consent to be handled? I think that's a really good way to start it as you start that journey with your patient. Try and put yourself in their shoes. I think note-taking and keeping of notes is absolutely critical. And this means, as De Niro was saying, don't just scribble in your notes that you spoke to them about it. Actually develop a form. And there was a question then saying, can EthiQal give us these forms? Have those forms. And I think just the last point I want to make is it is critically important that within your representative groups, whichever discipline you belong to, make sure that within your group, you create the expertise in these areas. And the only way you become an expert in these areas is by actually reading the books. If you know somebody in your discipline who's a coding expert, it's because they read the book. If you read all the guidelines, the ethical rules, the regulations, you read the acts, you have conversations about them, then you create that level of expertise and you can have these debates within your organizations. And then obviously there are organizations who represent larger groups, so that the South African Private Practitioners Forum. We represent many groups, and we therefore have a large intellectual property from which to draw, people with lots of experience. South African Medical Association has it, Health Professions Council has it, Medical Legal, there are lots of people. But within the healthcare environment, the big leadership groups like SAPPF and SAMA, we are there to help you out. But I encourage you to think hard about these things and to try and develop the excellence and the expertise within your society. And thank you very much for joining. And Amy, thank you very much to you for organizing and to the fellow panelists. Thanks, guys.
Thank you very much for that short and sweet wrap up. From my side, I would like to say on behalf of EthiQal, thank you very much to Dr. Strawn, De Niro, Mpho, and Shlombi for your expertise, willingness to share, and all your involvement in the preparation. Something like this doesn't happen without subject matter experts like you. So thank you for all your help. To the audience, thank you for your engagement. Thank you for the amazing questions and responding on the Q&A. It's always great to see that engagement. And we were trying something new today. So I'm getting a feel that it's working for you. Some of you have asked if there will be a recording available. It will be available. It will be available on the website from the 2nd of May. So if you want to come back and watch it or you want to share it with a colleague, it will be available there. Your colleagues will also be able to access CPD points for doing it. You cannot double dip, unfortunately, but if someone hasn't watched, they can do that. And your CPD certificates will be available within the next 4 weeks. Thank you all. Have a lovely evening. We're going to close the webinar now. As we close it, there will be a link for you to pop up, and please fill in 5 short questions for us on some feedback. It helps us develop webinars for the future. It's all anonymous, so if there's something that you didn't like, please let us know. This is really helpful. So to everyone, thank you all so much. Have a wonderful rest of your evening, and we'll be in touch